some food. Thank you for showing up here. Appreciate the opportunity to spend lunch with you. My name is Bill Hulsey, and I am principal with the firm Hulsey, Hunt and Parks. We do intellectual property law. The purpose of this presentation is to address the question of relevance of IP to startup success. And we're blessed to have some pretty experienced people that have dealt with startups, dealt with emerging growth companies, including my dear friend David Rodriguez, who is a partner with and co-founder of the Richards, Rodriguez and Steve firm, which is about 2 blocks away from here, at the corner of 9th and Congress. Our next guest speaker is Mike Wilfley, who has been a CPA, CFO, COO for a number of years and is with the virtual CFO firm, which, if you know anything about the accounting sector in Austin, Texas, that has served entrepreneurs and emerging growth companies for at least the past 20 years. Virtual CFO is the focused company who has grown from a couple of people, Ellen Wood being the founder, or co-founder, I guess, to a practice that's in many cities across the country, and again, sticking to the knitting, and that's working with growing technology companies, and Mike can tell you more about that when he talks. And then we're also very fortunate to have a good friend and client, Mr. Philip Bogdanovich, who is I have to confess, consumer of our services, but also a very active, exciting entrepreneur with a lot of experience to help make his company Hyperion Energy go, and he can tell you more about his background. I am a patent attorney and have been, there's Philip.
Sorry. I'm late being early.
We explained to them why your photograph appears in the post office with one of these.
Yeah, no, that's true.
But other than that, he is entrepreneurial. That's what. He can tell you more about Hyperion Energy. Philip is a top quality individual. Just finished a graduate program at Harvard at the same time that he was launching this the work that he's doing with Hyperion, as well as a number of other interesting companies. He'll tell you more about that. My background, I got into this business of intellectual property back in 1987, and there are probably some people in this room who weren't born in 1987, but been doing this for quite some time, have applied for, issued, licensed, litigated, acquired, sold all kinds of intellectual property assets in this in these 30-something years of investing in the process. Again, my practice, I was admitted to Vanderbilt Law School back in 1985, and when you go to a professional school or law school, they ask you to write a little essay as to why you want to get into that school. And my essay focused, I wanted to practice in Tennessee, ultimately, or originally, but decided to come to Texas. If anybody knows about the relationship between Texas and Tennessee, when you see GTT on somebody's door in Tennessee, it means gone to Texas. But at any rate, started doing that for my essay to Vanderbilt Law School was I wanted to work with emerging growth technology companies. And that's what we've been doing. That's what I've been doing for the last too many years. But we're not done yet. Let me see if I can get to the presentation. So, what I would like to talk to you today about is intellectual property. The theme of this is it's relevant to startup success. You can't afford to ignore your company's intellectual property. This is our firm, and I'll just give you a little bit of an advertisement. We seek to be that's me when long time ago. Yeah, young man back then. We have our main office here in Austin, Texas. We have a small office with a gentleman named John Tabara in San Antonio. Barry Young is a senior patent attorney who's with us in Palo Alto. I also have an office with a 30-person firm up in Rochester, New York. And on the 1st of this month, we opened an office in Memphis, Tennessee, which earlier this year, Forbes magazine named as one of the top 10 tech growth cities in America. And so we're excited about those opportunities in Memphis. This is some of the AV-rated firm, best lawyers in America, bar registered, preeminent lawyers. 10 of 10 superb rating on this AVO, which is the largest online service of lawyers. A+ rating with the Better Business Bureau, and twice received certificates of appreciation from the U.S. Department of Commerce. And it's about our team. Our team gets together every single morning and focuses on one thing, and that's client service. We seek to be a gold standard in IP for a competitive entrepreneurial marketplace. So to whom does this presentation pertain? You ever seen this one? It does. It pertains to you. It absolutely pertains to you. Now that I may have your attention, a couple of things coming up I'd like to draw your attention to. One, next week in Dallas is the USPTO, U.S. Patent and Trademark Office Regional Entrepreneurship Conference. On the 26th, there's an interesting session going on at the VO Mansion in Dallas on patent quality and the America Invents Act trials, which test patents. We've got on the 27th of August here in Austin, the Texas Intellectual Property Summit, which will bringing in Senator Cornyn and Governor Abbott. And on the 10th of September, we just got this firmed up today, we're having a talk at the IC² Institute on patent reform legislation. So the question, is the global IP system that's been reasonably stable for 50 years relevant to your growing business? Well, I think this says yes. What this says is, this is the chart from 1975 to 2015 of the percentage of the market value of the S&P 500 that has to do with intangible assets. And it's gone from 17% in 1975 to 84% this year. 84% of companies' values is tied up in intangible assets. So why does IP matter? IP matters because intellectual assets now account on a global basis for at least half of the gross domestic product of many advanced economies around the world. And innovation is driven primarily not by happenstance, but rather by markets and the expectation of profit from securing rights, legal rights to new technologies. IP rights also encourage, this is important, IP rights also encourage the more rapid and efficient transfer of knowledge across firms, licensing patents, licensing trade secrets, licensing or getting into cooperative development agreements. This intellectual property, this commerce of intellectual property provides an economy in corporate America's most valuable asset. Despite their grant of temporary exclusivity, IP rights are actually the most effective tool for knowledge sharing. Why? Because in order to get these rights, you have to disclose publicly what these inventions are, or identify that they are trade secrets, and be able to show that they are in fact trade secrets. But they do provide a mechanism for knowledge transfer better than any one that we've devised. We got problems though, okay? Anybody who's sitting in this room who's woken up at any time cannot say that they've never heard someone complain about patent problems. There are problems with patents, okay? There are problems with intellectual property rights, multi-billion-dollar patent lawsuits, doubts about patent quality, decisions diminishing the availability of patents for new technologies, and the role of patent trolls. This is the beginning of the concern in patents today. You want to sue for patent litigation where more than $25 million is at risk? According to the American IP Law Association, you're looking at legal fees and cost at about $5 million. And these multi-billion-dollar suits, this is a diagram of the smartphone competitor patent suits that existed in about 2012. They're going on today. Anyone see the movie Avatar? In Avatar, there's the real world, and then there's the people, the land of the blue people. Well, Avatar is, right? This is Avatar land. This is where all of these things are happening that don't affect whether or not you use or don't use your phone, but all of these legal rights are, and these disputes are going on in federal district courts and federal courts, not only in the United States, but otherwise. Doubts about patent quality. You know what this is? This is an invention that lets you breathe in a smoky hotel room. And this guy got a patent for it. Hello, why does that make any sense? Earlier this year, the Office of the Inspector General levied on the patent or conducted an analysis, a review, and a report on the United States Patent and Trademark Office on this concern of what we've come to know as crappy patents. And these crappy patents, the result was they discerned that the appraisal system for the USPTO examiners had nothing to do with quality, that the way that they've represented the quality metrics, they underrepresent the true error in patents. The USPTO is not collecting data that could improve patent quality. Okay, so we're not measuring, we're not collecting data. And then finally, the USPTO's response to patent mortgaging may not discourage abuse. Patent mortgaging is when an examiner, because he's got only so much amount of time to get something done, will submit product back to his chain of command, his administration, that hasn't been completed. And we've seen some of that here in the last, because of people trying to reach production goals and these things that are half-baked. We're dealing with one in the office right now. Things that are half-baked result in crappy patent. Last year, there was the decision you may have heard about called ALICE. ALICE is about what is patentable subject matter. The Fed Circuit in 2013 decided that this patent of this ALICE Corporation was not, you don't have time to get into detail on this, but what the essence was that this computer-related technology that had been developed was not proper patent subject matter. And we thought, okay, well, that was taken to the United States Supreme Court. And in the summer of last year, a unanimous decision was held because the claims are drawn, because the claims are drawn to patent ineligible subject matter, they're not eligible for patent under Section 101. You know what? This has been discerned by the patent bar, at least, to be an intellectually bankrupt decision. Interesting thing is the case never used the word software. It had to do with software, but never used the word software. And the failure to mention software a single time is breathtaking because it will render many hundreds of patents of software patents completely useless. The holding is about software because each of the ways that software has been used in this case had been traditionally claimed. They were ruled by this case to be patent ineligible claims. The story right now is about 75 to 90% of the patents held by people like Apple and IBM and Hewlett-Packard and others tested under this ALICE statute, the judicial decision may not be valid. The last thing is patent trolls. If you want to talk to someone who's not a fan of patent trolls, let's go to lunch. A patent troll is an entity that attacks businesses using an arsenal of attorneys and vague software patents. It has an immunity to patent lawsuits because it makes no products. It just sues people. And the idea is we'll bring you lawyers and lawsuits and you'll settle for an amount of money that's cheaper than your other alternatives, even though you don't infringe. Okay, so bad problems with the patent system, and then there's some worldwide systemic kinds of things that are at issue as well. The whole world is looking at the IP system with second considerations. The global IP sentiment seems to be at its highest level, they say, since the 1860s, when opponents to the intellectual property rights succeeded, and innovation in the United States went largely to a halt. That was when the quote you may recall or may have heard, where the patent office director said everything that could be invented had been invented, and that was 1857. IP, other challenges, IP is intangible. You can't see it, you can't touch it, you don't know that it's there. Digitization seems to allow everyone to effortlessly make and use goods and information. 3D printing, the ability to have, we've eliminated space, so the requirement, my computer right now holds a ton of more information, or more, than I bought it, but its weight hasn't changed at all. And as a result of that, and the ability to have this digital world has changed so much of that. Nearly, if not absolutely perfect copies at zero cost has become a reality. And then we have a generation, most of you in this room, that have been raised to see intellectual property as only an impediment to your ability to get and use easily created copies. There's some other problems that have to do with outsourcing and the separation between where something is invented and where something is made and manufactured. This loss of public confidence for all the first four reasons that I mentioned. And then even in corporations, because of some other decisions relating to treble damages and bad sanctions and the ability for people with patents to stop people, the best practice seems to be in corporate America, let's infringe and see what happens, which can be just a devastating thing. And then public confidence has eroded because licensing can be so constricted with high transaction costs and legal risks may exclude small and mid-sized businesses from participating. And I'll go through some of this, but the point is that we're under stress as a patent system, and that's not good for us. We've seen it 2 or 3 times in American history where this system, which began in 1790, has been put under stress. It's been put under stress, and when we ignore the system, our innovation, because people have not been compensated for the innovation and the work that they've done to create new businesses and protect it, has been put to issue. One of the things that's happened in the last couple of years is the World Economic Forum. The people that do the conference in Davos, they held a work group, and it was an interesting work group. They took people from the United Kingdom and people from Indonesia, and they tried to understand the concrete dynamics and conceptualize this kind of debate relating to intellectual property. They concluded, these were people that were in business, people that were in the professions, people that were in the judiciary, they concluded that we must develop a more robust set of educational efforts to explain the powerful role that in today's knowledge economy that intellectual assets represent, including intellectual property. So these are some of the proposals that they've made, and you're starting to see efforts to get these types of efforts into normal business. And it's about education. It's about rewarding creativity. It's about rewarding or facilitating access to these innovations. Well, one of the things that's going on right now is patent reform. Patent reform was partially successful in 2011 when we established the America Invents Act. Since then, we've had repeated efforts to do what could not at that time be done by the America Invents Act, and it looks like today that we're heading in that direction. So this Protect American Talent and Entrepreneurship Act of 2015 is about, the main target in this legislation is reducing the capability of patent trolls. So what they're trying to do, and looks like based on the lineup in Congress that we have, is to establish some procedural and practical restrictions on what people can do with regard to patent litigation. This legislation it was in June, in last year, third week of last month, the 24th actually, of June, it came out of the legislative committee. When they returned from their Labor Day recess, it's very likely that it's going to be heard in the Senate and passed. Representative Goodlatte in the House he proposed, when he got back after the Christmas recess, the first thing he did was resubmit his bill that was passed in 2014 by a margin of 325 to 91. And this bill in the House has 19 co-sponsors, Goodlight is a Republican, but 10 Democrats and 9 Republicans are supporting this bill, and it's very similar to the Senate version. And then patent reform has a lot of detractors from all stripes, but it also enjoys overwhelming support. And to me, having lived in this world of software patents for over pushing 30 years now, this is the endorsement that I like, and that is that the Electronic Frontier Foundation wants this to happen. If there's anybody, if there's any organization that's stuck to the knitting as far as patent reform and all the concerns that have now become ubiquitously understood, the Electronic Frontier Foundation has been just a real yeoman in getting this information out. So what I have decided to do on the 10th of September at the IC² Institute, this timing is going to be particularly good. We'll be talking about this issue, and we'll have a panel discussion on that. So getting back to this issue and just closing up on this is, so in the work that you're doing, startup or large company, intangible assets are where your value, that's where your value is. And so with all of the problems identified, it's still at our level of making things happen for emerging growth companies. Thinking about IP is important. So what I'd like to do at this point is identify 5 reasons why you should protect your IP as a startup company. First of all, the concept of provisional protection. You can apply precaution to the patent process. You don't need to spend a whole bunch of money, pay $10,000, $12,000, $15,000 to get your patent filed. The provisional patent application supports your getting an application on file as inexpensively and rapidly as you can afford. Secondly, you can learn if you can successfully take your invention to market after you've made the provisional filing. It's an abridged application that safeguards the filing date, but it also allows 1 year to file. The provisional app also provides time to research the market and prepare a full application, and allows you to decide if it's worth the investment to seek a full patent. It's never been easy. Reason number 2. You don't seek IP protection due to perceived significant costs, some people tell us. But you know what? Today, with micro-entity status and your ability to go online, you don't need an attorney to do this. To go online to the United States Patent and Trademark Office and submit a disclosure that teaches someone how to make and use the invention. That will get you a patent pending filing date using the provisional application. Now, we deal with a lot of startups. It's always a good idea at some point in that process, either before you file or after you file, to go ahead and get an experienced attorney or agent in the process, but you can get to the system yourself. And this system, which is first to invent as first to file versus first to invent, really puts the opportunity and the pressure on you to secure those rights as early as you can, because your date of invention is immaterial anymore. The third reason, why leave your intellectual property, your intellectual accomplishments unclaimed? As easy as it is right now to submit a confidential disclosure that won't be published for 18 months, if it ever is, it's something you can do. The law is designed to protect your right to exclusive control of your ideas and intangible assets. I'll be out of here in a second. And it helps ensure that you will profit from your work with reduced fears of exploitation. And trademarks, this is an important point. It's not just about patents. It's about the other things that are available to you. Oh, here's an important point. America is 4% of the global population. Do the math. 7 billion people on the planet, 3 million people, 300 million in America. It's about 4%. Globalization, the IP system supports that on the day that you make that self-filing of the USPTO. You can file separate and simultaneous applications. For some countries, regional patents are available. And we've got this thing. We have a guest here at Capital Factory on Monday from Switzerland. In Switzerland is Geneva. In Geneva is the World IP Organization. The World IP Organization provides this mechanism that by virtue of filing in the United States, electronic filing, you have the ability to seek international protection. And then the last point, and I'll close with this, is that competition, legitimate or predatory, rewards the first to file and may strip your ability to profit from the invention. You need to take control of your great idea and own it outright. That's where your value is. And then just as you ensure important assets such as home, business, and health, it's equally important to protect your ideas. So cleaning up on this, domestic and global pressures are on today's IP system. There are changes going on in Congress to address one of the biggest problems, and that's patent trolls. There's strong reasons to protect your IP, and protecting your company IP is highly relevant to your current and planned operations and success. And that's more than I had time for, but I will say another word, and then I'll pass this over to David Rodriguez.
Thank you, Bill. Okay. So my primary practice is mergers and acquisitions, and a lot of you in this group might be thinking, well, why do I need to be thinking about selling my company when I'm just trying to start my company? It's really never too early. The best deals that I've worked on are companies that I've helped start with, that have taken the pains to do things right, to get their house in order in each step of the way, and that's been able to get them the highest value when they decide to sell or to merge with another company or something of that nature. Oftentimes, in numerous deals I've done, IP has been a gigantic portion of the deal, if not the only asset that the company has. And so for today, I wanted to kind of outline 4 things that I've seen primarily that have affected a company's ability to get the most out of the value of their company. And some of these things are fairly easy to take care of. Some of them may not seem important at the time, but it's only when you get to an event that it really kind of hits home. One of them is a company not actually having or owning the IP rights they think they own. So, for example, the company might fail to update their corporate records when they have a corporate name change, or they reorganize, or they decide to do a complete reorganization of their company. They fail to kind of keep their paperwork straight. And not a big deal, but it is a big deal when you're trying to close your whether it's an investment round or whether it's a sale of your company as a whole. Failing to have your employees or the folks that actually work on your IP transfer those IP rights to the company. So, true story, I had a client that came to me. It was a gentleman that had just left Trilogy. He had an idea, he didn't have any money, but he had this pretty good idea. You fast forward, I helped him, you fast forward 7 years, he had over 130 software engineers who had worked on their software product. It was a software product that helped credit unions automate their decision making. A company in Europe wanted to buy them for north of $50 million. Process went really well. We were going through due diligence. We're starting to work on the deal documents. And the lawyer on the other side called me one day and he said, we have a problem. As we're looking at the documents that we've been going through, we've noticed that only very few employees and only a few contractors have actually signed the rights to the IP to the company. And we're not going to buy the company unless every single person that touched that software has assigned the rights. Not only has assigned them, but has assigned them in a format that we're comfortable with. And so that stalled the deal for about 2.5 months. We had to track down former employees, some who really didn't have any incentive to assign the IP, but eventually got that done. But that could have killed the deal and could have eventually ended up as a very, very bad thing. But we were able to work through it. So to the extent that you have folks working on your IP, it's important to make sure that they assign it to the company, because that's where you as the owner or owners are going to get the most value of that IP, because no one's going to buy the IP unless it's clean. So there's other things where another example is a client of ours that is in the manufacturing space, and about 25% of their manufacturing revenue comes from one designer, and this designer is in Vietnam, and the designer is very difficult to deal with, has a very gigantic ego, and in order for us to sell the company, we would have to lock down that designer for a number of years in order to satisfy our revenue numbers. And so we ended up taking about 6 months to have to work to get a deal in place with that specific designer that made them comfortable to permit us to be able to sell our company. Otherwise, we would have had to leave about 25 to 30% of the revenue or the sale of value of the company on the table. And if you're talking $100 million or more, that's a lot of money. So it's worth it to lock down things early, and probably say it a few times during the talk. The second big issue I've seen in M&A deals is prior agreements of the company that affect the company's IP rights. So I have another true story. A client of ours was a small company. They were approached by a Fortune 50 company to do a joint venture. And as part of that arrangement, the large Fortune 550 company required our client to place the software, the source code, into an escrow with Iron Mountain, which is a third party that will escrow software, the source code. Everything was working well. The client really needed this customer, and things went well for a few years until the buyer came up and wanted to buy our client. The problem was Fortune 50 company ended up not wanting to do the joint venture after all. Our source code was stuck in an escrow, and our buyer was not going to give us the money unless the escrow was out, unless the source code was out of the escrow. So unfortunately, that we weren't able to get the source code out in time for this buyer, so we lost the deal because we had agreed, because we needed to, or our client needed to agree to have this source code in the escrow to keep this client happy or the customer happy, but it eventually killed the deal. And so we eventually got the source code out of the escrow, but we don't have a buyer anymore. So, you know, you've got to kind of be thinking, you certainly don't have a crystal ball, but what you do today can affect you years from now or months from now. And so to the extent that you can manage your IP in a way that gives you flexibility, that gives you clear title, at least as far as the company's concerned, it's going to be much better for you down the road than otherwise. The third big thing I've seen is IP being subject to pending or threatened infringement claims. So I have a client that's also in the credit union space, different client, but in the software space. And they had a very good client that was a credit union, and their source code resided on their server. And the relationship eventually terminated. They didn't get the source code out of the server. A competitor came in and stole the source code. And just by chance, my client found out about this. So my client's in a dilemma now. It's not a sales transaction, but you know, the question becomes, you know, does our client sue the customer for allowing the source code to be in a situation where it can be stolen by a competitor? Probably not, because they don't want to be tarnished in the industry, but they don't want the competitor to get away with stealing their source code. And so they're in a little bit of a rock and hard place as to what to do, because they don't want to get the stigma of having to sue their own customer over a potential infringement claim, but time will tell. So that's the third thing. The fourth thing is a company having their IP rights subject to liens or judgments. Sometimes that's inevitable. Sometimes companies need money, they borrow the money, a bank or a financing source places a lien on their assets. It just happens they file also at the Patent and Trademark Office, and you're kind of stuck. What I've seen in the M&A deals or in the acquisition side is requirement by buyers to release all judgments and any liens that are associated with the IP before the deal closes or as a condition to the closing. So those are the four major things that I've seen in M&A deals, and I've been doing this for over 20 years. It's really critical to take a moment, even at a very, very early stage, to figure out, and if you don't really know the right questions to ask somebody like Bill or ask an attorney about, okay, I have this opportunity, I have the requirements for this opportunity require this, how's that going to affect me down the road versus today or tomorrow, but really down the road, because it could really make the big difference between making some money on a deal and making a lot of money. So that's all I have.
Well, you want to go to that?
Sure. Well, I don't know. Is there a
I think we're going to do
comment?
it. No, it's
Okay,
fine.
all right. So I didn't think it would be this hard to make IP, interesting and exciting, but you two guys have killed it.
We paid you to say that, didn't we?
Yeah. It's really boring.
Yeah, fantastic. So I'm a chief financial officer, and my primary comments are going to be around what scares the crap out of me with companies that have assets and liabilities. So the first thing, my first responsibility in many cases, and I've been a CFO of public and private companies, and is that I'm very interested in safeguarding the assets. And intellectual property, to me, is a pretty broad umbrella, and it includes what he's talked about with patents, which is an expensive exercise to go and perfect and get clear title to. But there are also trademarks, copyrights. You've got secret processes if you manufacture bourbon or something, and you've got some cute recipe. And there are other things that have value. And if I'm trying to manage how much money you've raised and how long it's going to last before you make money, I'm real interested in all of those things. A trademark, for example, I've been with companies where we've had to change our name or the name of something we were doing, and that is not cheap. And so going through the steps initially to make sure that no one else has a claim or a use of names that you use or pictures even. Just the oddest things that you would think you would have the right to start using, and all of a sudden you realize somebody's got a copyright on that, or somebody else has trademarked it. And if you've gone to any expense at all in preparing material or getting down the road advertising, start over and wipe out that cost and start over again. So, all of those things have an impact. When Bill first sent me to his flyer and asked me to sit on the panel, the section that is by my name has intellectual property as potential employee retention and as a part of employee retention. And my first thought was, I wonder if something new has been invented, because I don't ever think of intellectual property and employee retention. I think about it, you just don't. And I've spent some time recently checking with people and saying, am I missing something, or is there something else going on here that people are starting to do? And the answer is no. There are large companies that are well established, have big legal teams and departments, and want to share intellectual property ownership with scientists and people they want to attract to the company to do, big things. And that's one thing. There are so many unintended consequences from that type of relationship and that type of ownership. I'll just mention one name, Zuckerberg or whatever. The issues that go along with who actually owns things can really, to David's point, screw up deals down the road. And so my first objective are, understanding what the asset is, and I want the company to have clear title to whatever we're going to claim the company owns, and it's got to be in the company's name. And then I roll over to the liabilities and what are the contingent liabilities the company's going to have if we don't have the assets set up correctly. And that means it's really an HR issue. I want everybody that works for the company or does any work for the company to have signed a confidentiality agreement, an assignment of developed, what do you call it, agreement. I've never had to do that because I don't have any creative skills, but I have had to sign confidentiality.
We'll take care of it for you.
And you don't think about that a lot of times when it's just 3 guys in the garage or 2 people at the Capital Factory. But the bottom line is, at some point you could go different directions. And if you've got 2 or 3 people and everybody's contributing to a development project, and then all of a sudden somebody decides that they need to go someplace and do something else, if it isn't clear who owns all of that work that you guys have been doing together, then everybody owns it. And then everybody they touch owns it. It just gets out of control. And I'll let Philip maybe address some of these things, but that part of it is pretty scary. So I think it's important. And the startup companies that we've worked with, we always advise them to get good legal counsel at the very outset, making sure that you got the correct entity established, that how you want to operate. And I don't care, LLC, S Corp, C Corp, it just depends on what you want to do and how fast you want to get there. If you're going to attract outside investors, if you have a product that's going to be revenue producing right away, then you may lose money for a while, but you may want those losses to flow through to the partners, and so you want a tax pass-through type of entity, so an LLC or an LP or an S corp even. But if you're going to go get money from the street or from an investor, they're going to want you to have a Delaware C corp, because everybody wants to have the right to manage it, and for all of their agreements, and to be literally 18 inches of paper that are going to go into the first several rounds of equity that you bring in. So going back to, so the liability part is, it's an HR issue. You should have offer letters for everybody that is going to be an employee, and stay away from contractors, or make sure contractors, and it's hard to say stay away from contractors, but I live in a perfect world. So, that's what I want. I mean, you'll push the envelope and you'll do whatever you want, and I'll have to run around behind you and pick up the pieces. But if you're going to have odd people working on our development project, they're going to have to sign some paper, and they need to do it on the front end instead of the back end, because there will be a back end. It's much easier to get folks to agree to something when they're coming in the door than when you're ushering them out the door, and you will usher them out the door at some point. It just happens. I mean, not everybody, but I mean, people leave, and when everybody that leaves, you don't think about it until it's too late and they're left, and you're going, oh shit, this guy walked out, he could have, a bunch of stuff. And so, be smart about that on the front end, and that's human resources. So make sure you've got, and lawyers will help you draft up the agreements and whatnot, and they can be boilerplate, but just people to agree to who owns the stuff that you guys are developing and are intending to put into your product. A couple of stories, the patent troll exercise. I was the CFO of Grandi Communications for 10 years. It was a startup. We raised a whole lot of money. Along the way, early on, we were developing our website in order to allow consumers in the marketplace to be able to check and see if their address was serviceable yet for our cable television service. Well, our developers had used some open source code in part of the development, and lo and behold, we got in Marshall, Texas. If you ever get anything in it from Marshall, Texas, don't open it. Just done. I mean, East Texas makes a living off of phishing and patent trolls, and these guys, Epic Realm, had looped in a bunch of retail websites that use dynamic page stuff, and they said ours did too. And so we thought, well, God, what a nuisance! We're not making any money off of it. We're not charging. That's not part of our. It's not part of our point of sale process. It was just a reference, and we still couldn't get out of it. And that happened in 2005. We've gone public in 2004 with the debt, and then it's getting into 2007, and we need to start thinking about selling. And I've got this turd on the table that I can't hide any longer. And we've spent at that point probably $300,000 or $400,000 defending it. Well, we ended up writing a check for close to $700,000 just to get a perpetual license to breathe air, from my point of view. I mean, it was just ridiculous.
For a patent you didn't infringe in the first place.
Exactly. Well, from my point of view, we didn't. I'm sure those guys were, but Epic Realm was a entity designed solely to acquire patents to go off and perfect and to go off and sue people for. So operationally, as a chief financial officer and working with chief executives and boards and whatnot, it's really important to understand what has value for your company. And if it is going to be any form of intellectual property, take the steps early on to make sure that you have rights to it and that the company owns it. I know that if I'm going to go out and raise money with VCs, the very first thing in private equity, the very first thing, not the first thing, but one of the first pieces of due diligence, you're a startup company, you've got no assets. And so the only asset you do have is, your intellectual property in some form or another that you're bringing to market or want to bring to market. They want to make sure that they can get complete claim on that, so that if this doesn't work out in 2 or 3 years and you're in Series G and you're going to sell to somebody, they have the only thing left that has value, they can sell it. And they can get some of their bait back, because it's all about getting back some of their money if it doesn't go well. If it goes well and you can get to a transaction that David can help you with, then I'll let him deal with whether or not it's perfectly clear title. But I mean, you'll have the issues that he dealt with, but you should have, if you've got clear title, people will invest if you've got a good idea. And if you can maintain that, then that's going to make it better for everybody all the way down the road. That's probably not for me. I hope there should be some questions that come out of that too.
Let's let Philip talk about where the rubber meets the road, and then we'll do some questions here.
I feel like I dropped the ball. I should have worn flip-flops. It's one of the benefits of running a startup, right? You deal with the heartburn, but at least you get to wear flip-flops at the office. So I started as a Navy medic, and spent a fair amount of time getting shot at. And I can tell you that being in a situation trying to run a startup, having never done it before, there have been numerous times where I would have rather been getting shot at. For us, IP has been critical, because especially now, and I think one of the reasons why you see this trend towards intellectual property again is because there's been a movement coming out of the Silicon Valley and places like it where you start doing valuations pre-revenue, because your concept of what your company is capable of is going to be different and smaller than an investor like a Teal or Valentine that's looking at this thing, that's imagining from his perspective in the clouds of where this could be, right? And so you have to have something to back that, because if you're looking at it from a pre-revenue perspective, which we are not, or you look at it from a company that is now generating revenue, but you're small by comparison when you look at the industry, how do you really put a value on your position, right? Because Hyperion is ramped to, and I'm the CEO of Hyperion, we've ramped to a place where we're on trajectory to do over $1 million in revenue this year, and we bootstrapped the whole thing. It's been awful, but we have, and we've been successful. And when we're talking to investors and they're looking at Hyperion as a viable product for their portfolio, that's really what this is about, right? It's about being a product. To you, it's your sweat and your blood, and it's a lot of long hours, but to somebody else, it's a product. It's a product that goes in a portfolio that makes sense from an investment perspective. And so when you look at a market like Hyperion is in, like green tech, and we're looking at doing $2 million in revenue, we're so incredibly small compared to the value of the market that that's not what they're evaluating. They're looking at you from a technology perspective. What can they put in their portfolio that's really valuable? And so we filed IP. We have, over the last 3 years, filed for intellectual property on an application. We filed an IP. We filed IP on a control system. We filed IP on a monitoring system. And we didn't realize what we had, because to us it was just this thing that we used, and we built it to serve a purpose and because we wanted to be valuable to somebody. And when it got in front of Bill and the staff, it turns out that, for instance, one of these patent claims really was 36 individual claims. And so all of a sudden Hyperion became this really valuable thing, and we didn't see it coming, right? And so now we're looking at being a couple $1 million in revenue, but also we have really valuable IP because it changes the landscape of the market. And that's something that I could show someone. And when you're talking about a community on the investment side, whether it's the Valley or whether it's here, whether it's New York, and they say, well, how much revenue have you done? Whether you're pre-revenue or whether you're doing some incremental piece of what the market whole is, you can say, this is what I've done, but this is where the value is. I'm not Siemens Electric, but what I can do for Siemens Electric is compound exponentially their people's ability to sell. Right now, those guys are selling, they'll get a proposal back to someone in a week or 2 weeks. With our application, they can do 5 or 6 a day.
Might tell them what Hyperion does.
That'd be helpful. So, Hyperion is a green technology company. We started building LED solutions, and that has morphed into an ecosystem approach to what we believe the market landscape is going to look like. The lighting market has changed. It's no longer going to be just about selling an LED or selling any one particular thing. There's a principle coming out of business schools now where running a company or being successful is no longer about the real estate that you own. It's no longer about being a behemoth. It's about being a nimble company and how many people can you interact with and touch, right? And so that involves an ecosystem. That's what we believe very strongly in, and our solutions have been really rooted in the need to be able to compete with much larger companies. And so the application that we have built came out of a need to be able to deliver more effectively this lighting solution. And then how do we continue to interact with a customer that now has a product that will last for 10 years? Well, you build a control system that you can upsell or they can continue to interact with. And so we've built this needs-based ecosystem because that's where we see the market going. And in order for us to be viable in that space and really be a threat to a company like a Philips or a Cree, we have to have IP, we have to have something that's protectable because that's what the investor wants to invest in. Otherwise, we're just another really small company that might do some amount of revenue that's playing in a space that could do $30 billion a year, but we're gonna have a cap on how much we can grow because there's nothing really interesting and we don't have the marketing budget to compete. But when we go to an investor and we suggest that an infusion of capital will put us in a position post-money revenue where we can put this idea and this ecosystem and the sales capacity that we bootstrap to, coupled with this really valuable idea, well, now we have the opportunity to grow to a place where we're really a major market player, right? Because we built this little microcosm, this kind of test environment, and we know it works. We know the IP works because we use it. But the really valuable thing is I can say, if you put $2 million into this company, $1 million into this company, it grows us to a point where we're not doing $2 million over the life of the company, we're doing $50 million a year. Because now we have the technology and I can prove it because we filed the IP. There's value in that portfolio and I can show it to an investor who now can see my vision, and I'm not trying to explain my vision of a company or my vision of value. I can say we have IP on the things that do this, that make us valuable in this space because, and that fits into our model. And so all of the hard lessons that we've learned, I would say it is critical that how many of y'all are starting a company? How many of you guys in here are working on? So a lot of you. The guy in flip-flops to figure that. So it's really critical that when you're starting a company, you plan in the beginning because everyone feels, this sort of sense of duty to the company in the beginning. They feel if you have partners, things go really well in the beginning. You're in that kind of honeymoon phase of the relationship. And you're kidding yourself if you don't think that a business relationship is a marriage. It is, and they often go poorly. And so you have to protect it in the beginning. You have to put the IP, you have to work with someone, an attorney, because this is my attorney, the guy in the green shirt. This is Sam. This is my IP attorney. And in the beginning, they're kind of the adults in this relationship, right? They're making sure that even in that honeymoon phase, you see really what you're trying to do, which is build a viable company, which means if there is a split, if people come and go, the IP and the value of the company doesn't go with it. Because as soon as you make the conscious decision to start a company, your job is to feed it money and grow it, right? And so you're not operating in the best interest of the company if somebody leaves and takes the value of it. And so you have to protect it. So in the beginning, make sure that you build this in a way where the company is capable of protecting that intellectual property, that value of the company. Realize early on that there is a resurgence of interest in IP, that people are looking for that, especially in a pre-revenue model. When you're being evaluated and you don't have any assets, they're looking at intangible assets and you have to be able to prove it. And there are phases. For us, we began because we were bootstrapped. We started with provisional patents, which basically means I have an idea, I need a start date. And so that's what we did. We started with provisional patents. Bill Holsey and his team had access to it and it was filed. And then we have filed utility patents on that, right? And so we've made those incremental steps because we've been protected, which through this journey, when we've gotten in front of investors or very large companies, I know we're protected so I can talk about it. I know that I don't need them to speculate my vision because we have built an ecosystem around IP that I can share with them and show them and they can see it. Does that make sense? Like, it's really important that you can demonstrate your idea of how you work and what this is, and IP is a big part of that. And so now I know the company is protected because that's my responsibility as a CEO. That's my responsibility as a partner. I know that the real value of the company is not $2 million. And the $2 million in a $50 billion industry, it's not even a rounding error. So the real value there is the impact that our IP can have. And it's really hard for me to say, if we don't have IP, that the real value is in this thing that I can't talk to you about because I haven't filed on it yet, but it's a really good idea, trust me. It's a really hard, if you can make that argument to an investor,
It works.
you're better than me. I haven't even tried to make that argument. For me, it's been, we're protected as much as we could afford to be in the beginning, and now we've said, I've got this really good idea, trust me, we filed on this IP, here it
See if
is.
there's some questions.
So, yeah.
Anybody questions? Questions of Philip or yes?
So I came in a little bit late, but we filed a provisional. We converted to a patent that was actually issued earlier this year. But last year, there was something very significant that happened in the IP world, which I think is the 101 case.
The Alice case, you came in late, yeah. I touched on it, yes.
So give us a sense of your perspective of what's patentable and what's not, particularly with processes.
Sure. As a result of the Alice decision, there have been some people who said that many software patents are questionable value. That being said, the idea of protecting software that does something, software that uses a computer, that provides an input and an output. As a result of the Alice decision, the U.S. Supreme Court, the U.S. Patent Office issued guidelines as to what was not an abstract idea, and that was the whole essence of the Alice decision, is that the Federal Circuit Court of Appeals determined that what was at issue was an abstract idea, and you can't patent abstract ideas. That jurisprudence goes back to 1853 when Samuel Morse of the Morse Code sought to patent the electromagnetic effect, but it's a long piece of jurisprudence. The way to avoid this abstract idea preclusion for patentability, I think, has two important pieces. One is going in these days, and we've actually always looked at it that way. I've been doing this work such a long time. I can remember when software patents, and wrote software patents, when software patents were themselves first being considered. And back in January of 1996, the Patent Office gave some guidelines. I've always been of the position that the line between what's hardware and what's software is a line that moves all the time. It moves all the time. And if you draft an application with that knowledge, that the only thing that's really changing is how much software is doing, how much of a particular process or how much of a machine is software versus hardware. If you draft that application going in where you know that line is moving, then you're going to draft the application and you're going to draft the claims in a way that is as concrete as it can possibly be, and with the mind of, okay, I am trying to patent a machine. And if you look at a computer as a machine, part of it is based on instructions and part of it is based on what circuits do. But if you go in drafting that way, you're probably going to avoid a lot of the Alice type of decisions. Now, what happens with those patents that have been drafted without that view in mind? Most of the time, since the software jurisprudence does go back to that time, early time, and the people have been practicing that long, are the ones that have drafted these cases. If a patent claim, and it's really, the question is as to whether a patent is valid or not that's been issued, oftentimes it resolves to the issues, is the claim valid? Is the jurisprudence that pertains to this invention, has it changed to the point where this claim is no longer valid? Notwithstanding any ex post facto unconstitutional aspect of this, but that's an issue for another day. If the application has been drafted in a way such as I described, you can seek to reissue that patent with claims that are not now defective under the Alice ways of thinking. So there's a lot of remedy out there. The decision itself it's so abstract and vague, I don't know how much it holds up. But what we do know is we've got people like Justice Breyer and Justice Roberts that are not particularly patent friendly. But we know that we've got all of these companies here and in California and in Europe and Japan and Korea and elsewhere who have all of their value wrapped up in these intangible assets. I think this is a moving target, and I think at some point in time we continue to advocate that the patent system is a valid system, but it's not going to be a valid system unless some of these big problems, like trolls, like licensing issues, get cleaned up. And I really step back and look at it and say, all of this is an issue because intellectual property and intangible assets are more important than they've ever been. And a lot of laws that are on the books are ones that were created and established and thought about and codified when that was not the case. So we're still going through this establishment of what I call an efficient marketplace of intellectual property rights and working through this. But giving up on intellectual property and giving up on the value of the intangible assets that you're creating and doing and using in commerce is not the answer.
I have a question. So did you I'm just trying to go through what you just said here. So are you saying that you can file an application in a way that you can protect the process that software does to solve a certain problem?
Yeah, you can. Yeah, you can. A lot of it has to do with how you describe that process and claim.
So I just went through a similar thing. I had 2 provisionals I filed last year. We're a software and analytics company. I filed on the algorithms. We decided to trade secret them instead of patent. We decided to trade secret everything from now on. Is that what you're advising your clients as well?
Oh, really not. No,
Okay.
Absolutely not. The problem with trade secrets has been and always is and maintains today is that once you lose it, it's lost.
Yep.
Once you lose it, it's lost. And if you're going to grow to any measure, for a lot of these companies, even recipe companies such as Coca-Cola, for example, a lot of it's wrapped up at that point in the trademark. Because there's been enough press and enough science and all to reverse engineer the Coca-Cola formula or the 57 herbs and spices in Kentucky Fried Chicken or whatever it may happen to be. But unless you've got that type of trademark strength going forward, the trade secret, relying on trade secrets is a very challenging type of approach. I think there are trapdoors about.
Mainly based on, we'd have to, in order to make the claim, or in order to make the claims patentable, we had to define our algorithm so exactly that it would be very easy to get around it then, because they could just add another term to the algorithm and it would be different fundamentally from our algorithm.
Yeah, it's really hard.
The thing that convinced me was our IP attorney went through Google PageRank and said that that would no longer be valid today. I don't know if you agree with that, but that was his conclusion.
Yeah.
The algorithm, the PageRank algorithm, was not a valid patentable, but it was abstract as well.
Yeah, your questions are, it's one of those things that you learn after teaching intellectual property for going on 30 years now. The first thing that you don't want to give answers to in a classroom is hypotheticals.
Yeah.
Okay, and so it's one of those questions that I can't give you a good answer because I don't know what the facts are.
Yeah.
But I can tell you from a principle standpoint, relying upon trade secrets in lieu of patent rights oftentimes can be a risky thing. But the most important thing is to think that patent rights are the only means of protection is also just it's just as fallacious. We've got the statutes, we've got the system, we've got the best intellectual property system, just like we've got the best economy in the world, in using the trademarks, using the trade secrets, using the copyright system, using the trade secret systems, using the patent system. It's there, it's a self-help system, but it's something that's designed to help. And using the bankruptcy system, God forbid if you ever have to get there, but that's what makes this country go. It's our legal system that promotes entrepreneurship.
Can you speak a little bit to the differences and similarities between Bilski and Alice?
Yeah, the Bilski decision had to do with I'm not as deep in the facts as I am with Alice as I am in Bilski, okay? Bilski was abstract. Bilski, you can't find the Bilski patent application. It was never published. You could, at some point, when the decision was rendered, in some of the discovery documents, find the Bilski patent. But it was never published. It was never made public. But I did find it, and I did look at it, and all that it is, it's a 10-page disclosure that has nothing but a four equation system for determining the riskiness of buying energy futures over a period of time.
The hedging.
It's a hedging thing.
Right.
Alice, on the other hand,
so Bilski was just an idea without actually building a computer program, making the rubber hit the road.
didn't even have an algorithm in it. No, didn't even have an algorithm in it.
It's just an idea.
Yeah, the Alice was more concrete to some degree. A lot of these decisions that have applicability in software make it to the Supreme Court are ones that do not have the same level of particularity that an HP or an Apple or IBM patent have that describe this kind of system. And so it gets a lot of press as being software is never patentable anymore. But the fact of the matter is that software patents are being filed every single day. We just know what the patent office and the judges and justices consider to be important, and we play by those rules. That's what we do. Yes.
I have a question for you, Philip, or for you, Bill. How long would it take once you filed your patent? How long does it take? Does it just depend on the type of patent? Because I know, Philip, you mentioned you had several. You filed one for control system and one for the software. So how long did it take before you had to file the next one? Did you just time it or just?
No, how long? Well, the question is, if I understand, how long does it take to get a patent?
Yes.
Okay, it depends. It depends on how you file. Used to be that it was standard, it took about 3 or 4 years to get a patent.
Okay.
These days, there are a lot of options that are available to you. As a result of the work that our Congressman Lamar Smith and his co-sponsors put in place, we have Track 1 capability, which can usually get a patent to you within a year. We have ways that have been in the law for quite some time that will give you the ability to, based on your age, based on some other considerations, ability to be put in front of the line. And then there's some international considerations that can get you ahead of that 3-year domain. But it depends on what you want to do, and it can go. The shortest you're likely to see is a year. The longest average reasonable time is going to be 3 or 4 years, but that's not absolutely not maximum. Yeah. Yes.
If you file a provisional, that gives you 12 months here in the U.S. to file the non-provisional.
Right.
And I know it gives you like a filing date for international patent applications as well. Do you get that full 12 months for more or less all major?
All
developed
countries.
economies? Okay.
Yeah, that's deemed your international filing date.
Okay.
Yeah, you just have to take steps at that 1 year point. At the 1 year point, you have to do two things, right? If you want a U.S. application, you have to file your utility application with the United States Patent and Trademark Office. If you want international protection, you have to take steps to do that. The most common way is through the Patent Cooperation Treaty. There are other ways to do that are detailed, but they all base themselves on what's called the Paris Convention that says that if you file with the 1 year anniversary, by law, it's treated as having been filed on the day that you made your U.S. filing. Yes?
Can you just talk about continuation patents and what you normally use as a definition or guidance on whether something can be filed as a continuation patent versus a brand new utility patent?
Sure. It depends on what you're doing. If the subject matter is quite related, for example, we just got a request for an application in this morning at the office. It's a company up in New York City that has a number of e-commerce applications that they're protecting. And when we filed the first application, at the very last minute, the inventor said, "Hey, I've got this idea." And I said, "It's really, this is the basic concept, but can you also add that to the application?" It's not what the application was centrally about, but it was something that he said, "I'd like to get this in." Now, come 3 years later, he sends me an email last night and he says, "We are taking this idea to market. Do we have anything in our pending applications on this?" And I was able to say, "Well, you know what? You do, because," and I've been in litigation where this kind of situation was really important for a large integrated circuit manufacturer, just right off 635 in Dallas. I called and I said, "You actually do." And I said, "Is this the same concept?" "Yeah, but we've actually improved it a lot." And I said, "Well, let's file a continuation in part application, because that gives us the ability to tack on to the date of the originally filed application." And we haven't fleshed out the particular details on this to any measure, but there are a lot of benefits from being able to do that. Now, that's a continuation in part application. A continuation application, basically, it has exactly the same specification as the originally filed application. You're just pursuing different claims that are already disclosed in that same subject matter. So those are continuation in part. Also, there's the divisional application, but the divisional application has exactly the same specification. It's just divided. When you have, say, 20 or 30 claims in prosecution, you may have 10 or 15 that the examiner, you only get one invention per patent, and you may have claimed 4 inventions. And so the examiner will say, "I'll examine this one invention. I'm not going to look at those others." And you agree with the examiner which of the others are. And then if you decide later that you want to pursue those additional claims, that divisional application is what you call on that. But a continuation is a new filing. You're just keeping the same specification. You may change, in fact, other aspects of the background, may add other aspects, but the claims are different, and that's what you're doing. So that's that. Yes.
How has the Alice decision affected patent trolls? Are they pursuing litigation differently, or?
No, I think it's been one of its purposes. So what's going on? It's great question. So what's going on with Alice right now? Or what's going on in patent law right now? We've got these things that are going on in Congress. We've got these things that are going on within what I call the IP stakeholder community, with standards and with people pooling patents and all of these other things to try to address their particular market needs. In this area of patent troll litigation, there's been a substantial reduction in the last 18 months because of the federal judiciary saying, "We're not going to put up with this anymore." And the Alice decision and other similar decisions have gone to that vague idea and said, this is a vague idea. At least people like the situation that Mike, this is a vague idea. It's not specifically enabled in the specification. It's not specifically claimed in the claims that you're trying to assert. And as a result, this is not a valid patent. You lose. You may not even get to the court, but because these guys who are asserting these patent rights in these companies like Intellectual Ventures or Acacia or what's the
Epic Realm.
Epic Realm, these people, they're looking at jurisprudence and saying, we're kind of out of business to some degree. At the same time, patent troll litigation is going on, and in an effort at least to codify some of these concerns, that's what Schumer and Cornyn and Leahy and Smith and Goodlatte and others in Congress are trying to put into the law. So, and Alice, I look at in part as being a judicial answer to this troll litigation. So it's all related to the same picture. That's a great question. Okay, it's time to go. One more question.
I'm interested in, I have a question about public disclosure. So I feel like I read that if you show someone, like let's say you're creating hardware, you show someone your prototype, even if you don't show parts that, like the internal workings of like what makes it, do what it does, that still could be considered public disclosure.
It could be. The facts on that situation are really important to look at.
Okay.
Yeah, and it's usually, it can be a 30-minute to hour discussion with a patent attorney. What exactly did you do? What was disclosed? What did you say? Because there are two prohibitions. One is public disclosure, and another is the offer for sale. The interpretation of the prohibition of what is an offer for sale has changed as a result of the American Invents Act, what you can and can't do. So having some knowledge, thinking about that deeply, it's one that if you've done that, clearly on the front end, you don't want to file. I mean, you don't want to disclose until you file. But not everybody can do that, and not everybody can reach that awareness until after they've already disclosed something. And then if they have, or if they've taken steps in that area, what have you done? And what can be done with what you've done? There are a lot of things that a patent attorney can do to help you fix that situation that will make you think you've got, at the end of it, in terms of what you file, what you claim, and otherwise, that can make you aware that not all is lost if you make that kind of disclosure before you seek patent protection.
Yes. Is there a time period for public disclosure? 6 months?
Yeah, it's a 1 year. It's 1 year.
Is it a year?
Yeah, it's 1 year. That does it.
Bill, can I say a couple more?
Yes, sir, please. Anybody else?
Just real quickly, incentivizing your talent, you don't have to give them equity, despite what you might be thinking. There's alternatives to giving equity to your talent, things that are called phantom stock agreements or stock appreciation rights. So if you come to an issue where you have really, really talented IT people, and you feel like the only way to incentivize them is to give them a piece of the company, think about it, talk to somebody else, and get some ideas, because that relationship may change over time, and so when you get to an acquisition and you've had a sour deal or a sour relationship and they're gone and they still own a part of your company, that's problematic. The other part I wanted to mention, and Mike had mentioned this word before, boilerplate language in documents. I've seen a lot of money spent and a lot of money saved on boilerplate. What law you use if there's a dispute? Where do you resolve those disputes? Do you have to go to New York or California if you have a fight with the person you get involved with versus Travis County 2 blocks over? So boilerplate language can be critical and can make a deal more. It can make your life difficult. So just because it's boilerplate doesn't necessarily mean it's not important.
You want to sum up with anything, Mike?
No, I'm good.
Okay.
Just those two questions I thought were really interesting because I've been in your position and also yours. The public disclosure problem, I'm glad we made a phone call first. I called Bill, and I was in the car on the way to walk into a Fortune 50 company with a prototype as a startup, and I had to consult with my pet. Like, that could have been the worst outcome in the history of really bad outcomes. And so I called Bill, and we talked about specifically what I could and couldn't say. And we're protected, differently under provisionals than we are under utility, and now we're formally, patent pending on this stuff. But making the phone call first and understanding what you can say, because sometimes you just may not have a choice. If you have a prototype and you've got to share it, you've got to share it, and you've got to be able to talk about it, because nobody wants to invest in a black box, and so you have to be able to have that conversation. And so just make the phone call first and figure out how to mitigate your risk to the best of your ability. And to your point, it comes down to strategy. What is, when you come into a company, and for us it's Sam, but whoever the attorney is that's helping you establish this umbrella that is your company, understand, and it may seem counterintuitive, but understand your exit strategy in the beginning. Like, where do you think you might be trying to go? Because that's going to affect when and how you file. And so the kind of protection you need is going to be dependent on where you are in the life cycle, and it's always worth the conversation. So
that's it.
Thank you all.
Thank you very much. Thank you.